Yes.
May I seek your lordship indulgence with regard to part 2, item 3. I'm
Part
making
2, item
3.
3. Yes.
I'm making a mention on behalf of Mr. Lorem Tuaga, my lord. If it may be taken up after vacation, my lord. He has some
Consent taken?
Yes, consent is taken. And also with regard to part 2, item
Wait,
50.
let's finish part 3. Okay. Mention is made on behalf of Mr. Lalrem Tluanga, learned counsel for the petitioner, for adjournment of the matter with the consent from the other side. In view of the above, list the matter after the ensuing vacation. Yes.
And with regard to part item 15, my lord.
15.
Yes.
Yes.
The same may be taken up after vacation, but on 16...
Consent taken, isn't it?
Yes,
Okay.
my lord. My lord, if a date may be given, 16th of October, if possible.
16.
Yes.
Okay. Item number 15.
Yes.
Mr. Lalbiak Nunganamte, learned counsel for the petitioner, has prayed for adjournment of the matter with the consent from the other side. In view of the above, as prayed for, list on 16/10/2025.
Deeply obliged, ma'am.
May I please your lordship, in respect of part 2, item number 2, which is fixed for today, let the matter may be taken
Fixed
up.
for today. So what happened? Adjournment
Yes,
with the
adjournment.
other. Okay. Good. Mr. Lalpian Fela Chongtu, learned counsel for the appellant, has prayed for adjournment of the matter with the consent from the other side.
Can
In view of the above, list after the ensuing vacations.
I have a date, my lord?
On
7 October.
17/10/2025.
7.
7th,
Yes.
right after the vacations.
Yes.
Okay, on 7/10/2025.
Yes.
2025.
Oblige your lordship.
Item 1. Hearing. Item 1.
May I please your lordship? My lord, in this case, direction was given to by the Honorable Court for the state respondent to acquire the land of the petitioner, Vite order dated 13/4/2018, passed in WPC 53 of 2014, and the land was acquired by the respondent government. However, my lord,
Acquire the land. Then?
the district collector, who was authorized to determine the market value of the land, has failed to give an opportunity to for the petitioner to raise any objection regarding the land value, for fixing the land value. So, my lord, the land value was fixed at rupees 469 per
It
square
was
feet.
fixed without giving you an opportunity.
Yes, my lord. The land value was fixed at 469 per square feet, and it was approved by the government. However, my lord, the district collector failed to take into account the rate of rupees 1,148 per square feet fixed by him in the supplementary award number 1 of 2019, which is in relation with WPC 137 of 2019. My lord, in that case, the land value was fixed at 1,148 per square feet. And
A lot. The difference from
Yes, my lord.
469, it's more than double.
yes, my lord.
Okay, we'll issue notice. Let's see whether you have a case or not. Heard Miss Ruth
Dalwat Feli.
Lalwat Feli, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for the issuance of the appropriate writ or direction to the respondents wherein the petitioner is aggrieved by the amount of compensation fixed by the respondents on the acquisition of a landed property. How many petitioners? Okay, on the landed property.
Petition is only one.
On the, of his landed property covered by what?
LSC 10 of 1978.
Where's that mentioned?
Uh,
In your synopsis, it doesn't mention that. Covered by, where have you mentioned that?
I don't, just a minute.
Oh, okay, LSC 10/1978, which was acquired. For what purpose? Your synopsis is not very
For market,
informative.
yes, ma'am.
Okay, which was acquired for the purpose of,
Market cum community hall.
where's that given?
In para 2 of page
Page?
5.
Your synopsis should contain all that, so that we could say, instead of searching, isn't it? So, yeah, it should be a little bit more informative. Para 5,
Para 2, page number 5.
okay. For the purpose of the Tuampui Market cum Community Hall. Full stop. The Learned Counsel submits that on the acquisition of his landed property, the assessment made for the value of his landed property was taken at rupees 469 per square feet, whereas similarly situated persons were given the rate of rupees 1,148 per square feet in the supplementary award number 1 of 2019. Is it?
Yes, my lord.
2019. Then you had mentioned one judgment of this court as held in the judgment of the coordinate bench of this court in what, WPC? Where's all that?
WPC
number?
137 of 2019.
Where's that? Where have you mentioned that? Page? All that should be highlighted in your, this thing, synopsis. Your synopsis is very incomplete. I mean, at least those basic facts which you're mentioning now, no, they should be somewhere so that we
It
can
is in
just...
para 12, page 10.
Way back, in WPC number
137.
137/2019. Full stop. Aggrieved by the rate fixed for the acquisition of his landed property, wherein no show cause notice, you said, isn't it, was issued, was served to the petitioner at the time of the assessment of his landed property. The instant writ petition has been filed. Full stop. Issue notice to the respondents. Ms. Lalnun Lui, learned government advocate, accepts notice on behalf of the state respondents. No need to issue any other thing.
No, my lord.
no need to issue formal notice. Requisite copies of the writ petition to be duly furnished to the learned government advocate. List after 3 weeks.
Obliged.
Increase the AC. It's very hot. Yes.
Admission item 2.
My Lord, the matter pertains to
Counter filed.
one affidavit, advance copy was served to me last week. I don't know whether that has already been filed or not. And in the affidavit, my Lord, one thing I would like to point out at the outset is that this so-called reply affidavit was filed by 7 to 11, respondent number 7 to 11. This is a contempt proceeding, my
Oh,
Lord.
this is contempt, huh? So show cause. So I think we made the wrong order last time. We said counter affidavit, huh?
Excuse me.
So not complied or complied?
Not complied, my Lord.
Why?
This is order dated, my Lord, 17/3/2023, with the direction to the state respondents to consider regularization of the petitioners, SSA, within 6 months, my Lord. Although they have enclosed various documents, my Lord, but there's
Showing the
nothing to
steps
show.
taken?
Steps taken only for the IWAS, only for the namesake, my Lord.
Then by the next court date, what are the steps taken?
They have constituted a study team, one after another, study team. No progress is there in compliance with the direction of this honorable court, my Lord. Now this has resulted in lowering the dignity of this honorable court, my Lord. The petitioners, my clients, there were about 1,350 of them.
Yes.
Your Lordship, in this, we have filed an affidavit on 18/9/2025. Now, so as to avoid repetition, even though this is a contempt matter, in paragraph number 4, authorization letter is issued.
Para number 4.
Yes,
We're
authorization is,
taking steps, para number 4. Yes, let's see.
authorization is given to the deponent to file on behalf, because the sums and substance to be submitted before
Okay,
the honorable
7
court
to
is
11, huh?
Yes, it's one and the same. So what happened is that in this case, the direction of this honorable court was first to consider regularizing the services of the members of the petitioners association against the existing vacant post. Second is that, or in the alternative,
But wait, let's read the judgment.
Yes.
Where is it, page? Yes.
I have
Page 46, is it?
yes, I have also mentioned in paragraph number 7 of my
7, okay.
yes, paragraph 7. Yes. Shall I read? May I
Yes,
read?
yes.
That it is respectfully submitted that this Honorable High Court, in its order dated so and so, passed in so and so, had directed the state respondents to consider regularizing the services of the members of the petitioner association against the existing vacant post of government teachers in the appropriate grade, keeping in mind the experiences and training undergone by the members of the petitioner association and the object and mandate of RTE Act. Or, second, in the alternative, to sanction new post as SSA teacher by creating such cadre. Third, it would be open for the state to frame a scheme providing for further terms and conditions on such regularization shall be done. Such exercise should be initiated and completed within a period of 6 months from the date of receipt of certified copy of this order. So what happened after this, or passing of the direction of this honorable court, is that there were 2 options given. That is to create or a new post for the cadre of the SSA, or to frame a new scheme. Now, in that regard, the government have taken a policy decision to make one scheme for the CSS employees under the Mizoram government.
So have you enclosed the scheme here? Have you enclosed a copy of the scheme?
Yes, Your Lordship. It's Annexure 4, page 24.
Wait, let's read the judgment instead of
All right,
reading
all right.
It's number 47, my lord.
47.
Para 23. All these sentences under para 23 has to be read together, not in isolation.
Okay, read para 23.
And thus,
Oh,
Upon
yes,
due con-
okay.
upon due consideration of the case in its entirety, I find that the grievance expressed by the petitioner association to be legitimate and has merit. Accordingly, the state respondents are directed to consider regularizing the service of the members of the petitioner association against the existing vacant post of government teachers in the appropriate grade, keeping in mind the experience and training undergone by the members of the petitioner association and the object and mandate of the RTE Act, or in the alternative,
Or in that, this is the second choice, sanction,
to
yes.
sanction new posts as SSA teachers by creating such cadre, whether in the existing vacant post or in the new sanctioned post, my lord. And there's a rider. It would also be open for the state government to frame a scheme providing for further terms and conditions on which such regularization, my lord, shall be done.
So the last part,
Under any
scheme, it's not
circumstances,
an or. It's not or.
it cannot be written in
scheme.
isolation, my lord.
It has to be, it would also be open. Besides satisfying the first two conditions, which is the first one or the second one.
Yes, my lord.
And then at the same time, it would be open. That is this thing. So read the operative part of the judgment again. There are no three ors. There's just one or. There are no two ors. There's just one or. So 1 and 2 is the option given. And then the third one, which you have said, the scheme, it is after a full stop.
Yes.
That means it would also be open.
Correct, Your Lordship.
Yeah.
So that is
So
why
you have done the third one, not the,
the third one is
and.
it would be open for the state government to frame a scheme providing for further terms and conditions on which
Further
such-
terms.
Yes, such regularization shall be done. So accordingly, we have taken a policy decision to make a frame. Now the regularization is in process. Like my learned friend have rightly submitted, study team is conducted because there are thousands and thousands of persons that is involved. So it cannot be done in 6 months' time, Your Lordship.
Okay, so what, in your show course, let's see what are the steps. So have you at least enclosed the copy of the scheme? One thing,
have
something you
enclosed
have
in
done?
page number 24 and Annexure 4. This is the scheme.
Page
Page 24,
24.
Annexure 4.
Oh, okay. Regularization of centrally sponsored scheme for employer 2024. Okay, at least one thing has been done.
Yes.
Now the next two
Truly.
steps you have to pursue, make sure that keeping in note that this court,
Yes. Yes.
I had said that it should
Your
be
Lordship, if I may,
completed within
if I may
6
take
months,
your
yes.
Lordship kind attention to Rule 3 of the scheme.
Okay, rule 3, yeah. Yes.
The state government in the concerned department is responsible for determining the number of employees under the scheme to be considered for regularization. So it's not that we are not trying to regularize them. Now, steps are
But the
taken.
petitioners in the WPC, they have to be given consideration because what is the language of the court?
They are given
Yes,
consideration. How can we
see,
say that we are not
it's
giving
the
consideration? Your
here,
Lordship?
of the members of the petitioners association,
The members of the petitioners associations are included in the scheme.
not all the petitioners. See, you have to read the language, huh? Okay.
All the CSS employees under the Mizoram. So this scheme,
This is, see, you just concentrate on the writ petition. Don't go beyond that. This contempt is filed by the Mizoram SSA Teachers Association.
correct.
Okay. So you're saying that the scheme also includes the present petitioners. Is it?
Yes, they are included.
But,
Yes,
so we are going to pursue the contempt.
yes.
not all the other CSS. That is not the issue
Yes.
here. Okay. So in this particular contempt case, we have to concentrate on how do you comply
how-
with the
yes.
judgment of an order concerning the Mizoram SSA Teachers Association.
Your Lordship, if I may take Your Lordship kind attention to page number 23.
23.
Now, this checklist for submissions of proposals was, by way of OM, was notified.
Yes, where's that?
22,
22. Yes.
yes. And in page number 27, meeting was convened for the implementation. This SSA now becomes, with the amalgamation, it's Samagra Siksha. So we have to note that, Your Lordship, because SSA is not there anymore. So under the heading of representation of Samagra Siksha Mizoram employees. So it was considered.
How is it considered? Read para 2.
The study team was conducted,
Will comprise of
was
the
comprised
following
of,
members.
yes,
This is dated 27 June 2024.
2024, yes.
So what happened to the study team? Where is the report or what outcome of the study team?
and accordingly notification was issued on 1st July 2004 notifying the study team.
So 24 last year. Then
And in August, in page number 29, study team, the governor of Mizoram is pleased to order the study team under School Education Department for implementation of government regularization of centrally sponsored scheme 2024 and to make recommendation. It was notified in August 2024. And appointment of the Deputy Director, SCERT, as member of the study was notified in August 2024. In October 2024, in Annexure 9, page 31.
8 October, what happened?
The Constitution of Performance Evaluation Committee was set up. The petitioners are from different states. Different districts. I'm sorry. So it's not feasible to have a blanket umbrella.
So when do you think you'll be able to comply? Because the judgment is there, there's no appeal.
Yes.
So within
Neither
6
they have
months,
applied for extension of the judgment, that period, my lord.
Okay, so where's that extended up to?
It
They
has
have
not been
applied.
applied, it has not been applied by the
We
state
have
scholars, my
not,
lord.
but we have,
Instead, they have taken this or that way stand.
So since you have not complied with it, it has to be within
This is flagrant
6
violation of
months.
this. fourth
Yes,
month.
6 months. The option is, this court understands the problem which you are facing.
Yes.
But you apply for this thing,
yes.
extension of the time by the next court date, and then see
Okay.
how long can you, and then find out within the period,
Yes.
what period you'll be able to complete.
Yes, Your Lordship.
So your application also should be a little bit practical, okay? Like,
Understand.
and in your application, you also highlight whatever, in addition to this, why have you applied for so much period of time? Because this are yet to be done, which is likely to be, so that it is acceptable by
Duly
the
noted,
court.
Your Lordship.
Oh,
If I may be allowed to point out one more point, my lord. That scheme, which my lord friend has just referred,
It's very
that is a
general.
blanket scheme for CSS.
It's very general
not in
for the whole
constraint to the direction
CSS.
of
That's
this
what
court.
I've pointed out.
And after filing this contempt petition, my lord, there is a meeting minute of the high official that the petitioner's hearing will not be included in the scheme. But then after, with the vigilance, surveillance of this honorable court, under the contempt proceeding, my lord, the the then Director of Education Department had filed an affidavit in this case, saying that after the discussion and consideration with the council, they will also be brought into under the scheme.
Otherwise they'll have to face the, yes, rod, isn't it? Yes, anyways. Heard Mr. Victor L. Ralte, learned counsel for the petitioner, along with Ms. Mary L. Kiante, learned government advocate for respondents number 1347-11. And yes,
Lordship, for respondent 2 and 5.
for for respondents number 2 and 5. What do you have to say in the matter? Okay, yes. But who is 2 and 5?
They were the then Secretary and Director of Education Department who have the
Okay, so it's all the
Retired and
government officials, huh? 2 and 5. The learned counsel for respondents number 1347-11 has filed the show cause reply showing the various steps which was taken by the respondents for the compliance of the judgment and order of this court dated
17/3/2023
17/3/2023 in WPC number
128
128/2019.
2019.
So, the learned counsel for the said respondents submitted that though the respondents are making the best effort for compliance of the stated judgment and order, however, they are not able to fully comply with the judgment and order within the stipulated 6 months time. She has therefore prayed that she may be allowed to file an application for extension of the period given by the period
For compliance.
as mandated by the judgment of the this court in WPC so and so for the compliance of the same. Yes. In view of the above submission, considering the difficulties expressed by the learned counsel for the respondents number so and so, okay, same number, this the matter after
1 week, my lord.
after the vacations, okay, for
Yes, my
the
lord. After 1 week.
learned counsel for the learned counsels for the respondents to file their application for extension of time. Yes.
Item 3.
May I please your lordship?
Yes, what is this about?
Lordship, in this matter, lordship, I am for the respondent number 6 and 7 for income tax department, lordship. Lordship, we need some more time, lordship. Sir,
What is the criminal petition about?
This is Your Lordship, this is a very simple case. It's about violation of procedure in handing over of the seized cash by the police to the income tax department. So at last court date also, the respondents 6 and 7 prayed for
Okay, we'll give them
another
final
time.
chance. We'll give them final chance. We'll give you a final chance.
Let it be, if I may, Your Lordship, let it be
Lordship,
at last,
Lordship,
this-
Lordship.
let it be last chance, if Your Lordship
Isn't it-
permits.
For how many times have you prayed for time? Let's see.
2 weeks, 2 weeks time, lordship.
Okay, okay, anyway, Mr. J. Mal Somzola Wantong, learned counsel for the petitioner is present along with Mr. Your name is not shown in the cause list, along with Mr.
Lordship, I am
More.
J.P. Moore on behalf of Mr. H. Chetia, the Senior Standing Counsel of Income Tax Department.
Okay, even that is not reflected in the cause list.
Not reflected,
Along
lordship.
with Mr. So-and-so, you give a name later, appearing on behalf of Mr. Standing
H.
Counsel.
Chetia.
H.
Mr.
Chetia.
Suman Chetia.
S. Chetia.
Chetia, learned standing counsel for the
Income tax department.
Income Tax Department. See, nothing is reflected in the cost list. I think
Yes,
the
Lordship.
Learned Counsel for the True VC. The Learned Counsel for the Income Tax Department has prayed for further time to file their objection, is it to file their counter affidavit? Full stop. Then,
Yes,
what
Your
about the
Lordship.
state? Have you filed?
No, Your Lordship, we haven't filed yet.
Miss, are you going to file?
No, my lord, we will not be filing,
Ms.
and we will
Vani
have
Sawhney.
oral argument.
Learned Counsel for the state respondents submit that they will not be filing any counter affidavit. Full stop. It is seen that the counsels for respondent number 6 and 7 has prayed for adjournment several times for them to file their counter affidavit. In view of the above, this court find it fit to give final chance to respondents number 6 and 7 to file their counter affidavit. We'll stop. List the matter. Well, when will you
Date
be
may be
ready?
fixed.
Pardon?
Lordship, date may be fixed, Lordship.
Okay, how long will you take? This is your final chance. Is the
Lordship,
matter
2 weeks, after 2 weeks.
after 2 weeks on, give it any date after 2 weeks? Court
Lordship,
Martial-
16th of October.
Okay, on the 16/10/2025, yes.
Obliged, Lordship.
Obliged.
Item 4,
You can add the names, the name of the standing counsel for respondent number so-and-so is to be reflected in the cost list. Yes.
Lordship. Lordship.
item 4 to 6.
Yes,
Yes, Lordship. This is an appeal, MAC appeal against the judgment and order dated 18/10/2024.
notice complete?
Notice has been completed.
It's complete.
Yes, Lordship.
So this is a MAC appeal, statutory appeal, is it?
Yes,
So appeal will be admitted?
yes.
Under which section have you filed the appeal?
Under 173.
So statutory appeal will, what is the appeal about? What are the grounds of appeal?
The the insurance policy was a private car liability only policy, and the claimant, the deceased, were the occupant of the accident vehicle. So
Okay, so you're saying it's not the insurance, it's not covered by the
yeah,
insurance
it's not covered by the
policy.
insurance policy. Yeah.
So the owner, but the owner, notice complete, but they have not appeared. Through dusty mode, did you make an attempt?
Yeah, we have already served a true dusty mode.
Okay, so. Was he represented in the, before the tribunal? Because if
No,
they were-
no, they were not represented.
they were not represented then also. Anyways, Mr. Lildinliana, Learned K. Lildinliana, Learned Counsel for the appellant is present along with Mr.
Galmang Isanga.
Dalpanga Isanga,
On behalf of my senior, Mr. Johnny Altosa.
appearing on behalf of Learned Counsel, appearing on behalf of his senior, Mr. Johnny L. Tochong, Learned Counsel for respondents number 1 and 2. Stop. It is seen that though notice was deemed to be complete upon respondent number 3 and 4, by this court's order dated 22/08/2025, however, none appeared on behalf of the respondents number 2 and 3. Stop. This court On hearing the submission made by the learned counsel for the appellant, finds that this matter is a statutory appeal under section 173, is it, of the MBA Act, wherein the appellant has denied their liability to pay the awarded amount. In view of the above, appeal is admitted. List the matter. Was LCR called for?
No, not
Okay.
yet, Your Lordship.
Appeal is admitted. LCR to be called for. Make it TCR, okay? TCR,
LCR has arrived.
okay. Then cancel that. Appeal is admitted. Matter to be listed for hearing in due course as per its own term.
Thank you. Oblige, Your Lordship.
Item 7.
May it please your lordship, the parties have consented to refer the matter to mediation. To refer the matter for mediation. So if your lordship permits.
I've heard Mr. Ramchana, learned counsel for the petitioner, along with Ms. Ladman Louis, learned government advocate for the state respondents. So it is submitted that both the parties are willing to have the matter sent to mediation. In view of the above, matter to be sent for mediation, full stop, registry to do the needful.
Oblige, my lord.
Item 8.
My lord, this is the first appeal preferred against the impugned judgment and order passed in civil suit number 105 of 2017, dated 24/6/2025, wherein a payment of compensation amounting to 12 lakhs was imposed against the present appellants, my lord. The case is,
You were
I'm
compensation for what?
at
What damage
compensation
did you
for,
do?
my lord, the allegation is that the respondent is a student of class 7 in the school run by the appellant number 1 and 2, wherein the appellant number 3 is the teacher. And the allegation was that the present respondent was hit by the appellant number 3 during the class hour with a wooden duster.
With a duster?
With a duster at the forehead, yes, near his right eye.
Okay, so
And due to which it was alleged that he had suffered loss of eyesight of his right eye.
So can you come to some, have you tried to settle the matter amicably? I think this is appropriate. It's concerning the amount compensation, isn't it? So you are appealing, saying that when you hit the girl with the duster, he had not caused the injury to the eye. Is that your stand? Why
Yes,
have you
that is
filed
my-
an appeal?
This decision taken by me, yes, my lord.
But you did throw a duster at her.
That was also denied, my lord.
Actually, this is the case where an FIR should have been filed. And then proper investigation, isn't it?
Yes.
Anyway, so you try and settle the matter between both the parties. You find out.
My lord.
But we'll have to issue notice first. We'll
Mal-
issue notice.
Mal-
Let them know what is going on. Then if they have a counsel. So actually here an FIR should have been filed. Investigation should have been done if you didn't know.
No step was taken into regard during the relevant period also.
The right eye. So here it says that he has the habit of physically assaulting the students, it appears.
That was only the
So
allegation.
how many witnesses were produced by the, maybe the plaintiff
Yes.
in the trial court? How
Yes.
many witnesses were there?
Witness,
Maybe
Around-
students?
Around 3-4 witnesses were produced.
Are
The
they all
classmates
students?
were also produced, but
Classmates.
the medical doctor was not produced, my lord. But only after conducting the oral argument, the medical doctor was called by the trial court in the absence of the parties.
So what was the finding of the medical doctor?
The medical doctor said that injury might cause the loss of that eyesight. That is the opinion, but no chance was given to cross-examine the medical doctor.
Anyways, we'll issue notice first. After that, once the respondents are duly represented, I think this is an appropriate case to refer for mediation. Okay.
My lord.
Anyways, heard Mr. F. Lal learned counsel for the appellant, who has filed the instant appeal under section 70 within brackets 2, close bracket, then within brackets small b of the Mizoram Civil Codes Act, 2005, read with section 96 of the Civil Procedure Code against the judgment and order dated 25/06/2025, passed by the learned civil judge within bracket, senior division, close bracket, -5, Roman 5, okay, comma, Aizawl district in civil suit number 105/2017. Let's stop. The learned counsel submits that the appellant is aggrieved with the order of the learned trial court, wherein he was directed to pay a compensation of rupees, how much? 12 lakhs?
2 lakhs is to be paid by the appellants number 1 and 2, and 10 lakhs is to be
Okay.
paid by the appellant number 3.
Okay, so the learned counsel for the appellants, okay, S every time, wherein the learned trial court had directed that the appellant number 1 was to pay a compensation of rupees 2 lakhs to the respondent, and the appellant number 2 was
3.
required, 3. Okay, who's 2?
1 and 2 are directed to be paid 2 lakhs.
Okay, each.
2 lakhs, one
Okay,
each.
okay. So instead of 1 and 2 to pay a 2 lakhs, and respondent number 3 to pay a compensation amount of rupees 10 lakhs on the event of the injury caused to the right eye of the respondent, which is alleged to have been caused by the appellants. Stop. Notice be issued to the respondents through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks.
My lord, in the meantime, the operation may be stayed till the next returnable date, my lord. Operation.
In the meantime, as prayed for by the learned counsel for the appellant, the operation of the impugned judgment dated so and so, okay, is to be stayed till the next date of listing. Yes.
Duly obliged.
Orders, item 9.
May please be lodged. My lord, the respondent number 1 have filed their affidavit in opposition to my IA, and the rest are the state pro forma. And
Okay, we'll list it immediately after the vacation.
yes, ma'am.
Okay. Heard Mr. Lalbiak Nunganamte, learned counsel for the petitioner, along with Mr. K. Valal Puya, learned counsel for respondent number 1, and Mr. Samuel Valal Shetatsangte, learned additional AG for state respondents number 226. It is seen that the learned counsel for respondent number 1 have filed their written objection. In view of the above, matter may be listed immediately after the ensuing vacation. Yes.
Deeply obliged.
Item 10.
Yes.
May please, Your Lordship. My Lord, It appears that any card has been returned with respect to respondent number 1.
Are you going to file any objection? 23 days.
My lord,
So notice complete upon all the respondents?
with respect to respondent number 1, although I have been informed at the bar that someone will be representing him.
Okay, but no one is private
Yes, no one
respondent,
appears
isn't
today.
it?
Yes, my
Then one is private respondent, the others are all state respondents?
Correct.
Okay. State respondents, you're not filing the accountant, 23
I
days?
have not received instructions as to whether we're going to file
Okay,
it.
most probably you won't file. Anyways, heard Mr.
Eldrin
Eldrin
Zotan.
Zotan Moy, learned counsel for the applicant / appellant, along with Ms. Lalnun Louis, learned government advocate for the state respondents.
Your Lordship, there is no information or document to furnish in the RFA is what my instructions are, Your Lordship. Your Lordship, we will not be filing any,
No, who submits
Yes,
that, they will not be filing any written objection, full stop. It is seen that though notice was issued to respondent number 1, there is no return of service of notice upon respondent number 1. In view of the above, we may await for return of service of notice upon respondent number 1. List the matter after the ensuing vacation.
much obliged, Your Lordship.
Item 11.
May please, Your Lordship, my lord, if I may be given 3 weeks' time to file affidavit in opposition. I am for the respondent number 1.
Okay. How many respondents are there? 1 and 5 others. Who are the other 5?
The state.
State, okay.
These are pro forma
Pro
states.
forma,
State is
okay,
3 to
yes.
6, my lord, will not be filing anything.
Mr. T. Lalzikima, learned counsel for the applicant / appellant is present, along with Mr. Zoram Chana, learned counsel for respondent, private respondent number 1. And Mr. Samuel L. Sanke, learned additional AG for the state respondents. The learned counsel for the private respondent number 1 has prayed for time to file his counter affidavit, while the learned additional AG submits that the state respondents, being pro forma respondents, will not be filing any objection. In view of the above, list after.
My lord, my lord, immediately after vacation, because
But
there is
let them be
there's,
ready, let them be ready immediately.
there's a pending case before the trial court. It
okay.
is listed for hearing.
Will you be ready after the list after 2 weeks?
2 weeks, man.
My lord. Obliged.
Obliged, my lord.
Hearing item 4.
None appeared for the parties on court. List after 3 weeks. Anything else?
Item 7.
None appeared for the parties on call. List after 3 weeks. All the others, whichever. Anyone for the
Item 11.
in item? Okay, same order. Item 11, I think we have already passed some order. Okay, no.
No.
So item 11 and then the rest
Yes, it's
not
finished.
required.
Yes.
Registered immediately after vacation, my lord.
You are for what?
Appellant.
Okay, you forgot that you're 11, is it? Okay, anyway,
The other parties are not appearing.
Mr. Zoram Chana, learned counsel for the appellant is present, while none appeared for the respondents. In view of the above, list immediately after the ensuing vacation. Yes.